The issue of judicial deference to administrative agency interpretation of congressional enactments has plagued federal courts for decades. For 40 years, that deference was defined by the United States Supreme Court's 1984 decision in Chevron U.S.A. versus Natural Resources Defense Council, Incorporated. The Clean Air Act directed the Environmental Protection Agency, or EPA, to set national air quality standards. In the Clean Air Act amendments of 1977, Congress created additional rules for states that hadn't met the earlier air quality standards. The amendments required the non-attainment states to establish a permit program to regulate new or modified stationary sources of air pollution. Pursuant to the amendments, the EPA initially wrote regulations that defined a source of air pollution to be any device or piece of equipment that emitted pollutants. A plant or factory containing multiple polluting devices had to obtain a permit for each polluting device, demonstrating that each device satisfied the statutory standard. But in 1981, President Reagan's EPA administrator, Ann Gorsuch, adopted a different definition of source. Under what was called the bubble policy, an entire plant, factory, or facility could qualify as a single source as if it were encased in a theoretical giant bubble. That would allow the facility to install or modify an individual piece of pollution-generating equipment without a permit if the alteration didn't increase total plant-wide emissions. The Natural Resources Defense Council petitioned the United States Court of Appeals for the District of Columbia Circuit, challenging the 1981 regulations. Chevron U.S.A. intervened in support of the regulations. The Court of Appeals set aside the new regulations. The United States Supreme Court granted cert.